attorney, and the scientist says that, see, this is invention I have made and nobody else has made it before. So please file a patent and we should get a patent. So even though the scientist is saying that this particular part is a novel part, then also we should be able to identify what the invention is from the scientist work. And the invention means a new product or process involving an inventive step and also capable of being made or used in the industry. Now, to get a patent, there are certain patentability criteria. Now, these patentability criteria include novelty, inventive step, and industrial applicability. Now, novelty means the matter which is disclosed in the specification of a patent should not be published before date of filing of patent application. There should not be a prior art for that particular invention which is disclosed in the specification. Then and then only it will satisfy the novelty criteria. So the second criteria is inventive step. The invention should not be obvious to a person skilled in the art in light of prior publication, knowledge, or document. Like if there are 2 3 prior art documents or 2 3 inventions which are made before, and if you are combining those 2 3 prior arts together and saying that this is my invention, then that will not constitute an inventive step, because it is obvious for a person skilled in the art to combine those 2 3 arts and come up to the invention and file a patent application. So it will not satisfy your inventive step. So the invention should be not obvious or non-obvious to a person skilled in the art. Then of course the patent should have industrial applicability, then and then only it can be granted. So to satisfy all these criteria or to evaluate all these criteria, prior art search is very important, which includes patent or non-patent literature. Most of the time in the industry, while preparing various reports for various products, we spend a lot of time on prior art search because it is very important task. Because then and then only we come to know whether the invention which we are trying to file or we are trying to protect is patentable or not patentable. So coming to what are not inventions, as we have seen that what can be patentable, different criteria of patentability, we should be also aware of what are not inventions according to Indian Patent Act 1970, which is amended in 2005. So there is long list of long list of things which are not patentable. So invention which is frivolous or contrary to well-established natural laws, invention which causes serious prejudice to human, animal, or plant life or health, or which causes prejudice to the environment, the mere discovery of scientific principle or formulation of abstract theory or discovery of living or non-living substances is not patentable. If you are discovering something which is living thing or non-living thing, then it's not called as invention, it is just a discovery. So the section 3D, which I'm going to talk upon, is a very important section, which is a much debated section and which differentiate Indian patent law from that of other patent laws of countries, developed countries like United States. So this is section 3D, which is about mere discovery of a new form of a known substance. New form in the sense that if a chemical compound is already there and you are coming with its new form, like its salt form, its ester form, its ether form, polymer form, or any other form, then if it does not result in the enhancement of the known efficacy of that substance, then it cannot be patentable. Or the mere discovery of any new property or new use of known substance or of the mere use of known process, machine, or apparatus, unless such process results in a new product or employs at least one new reactant, then and then only it can be patentable. Or if it is not employing at least one new reactant or yielding at least one new product, then it cannot be patentable. So this section is very important section for chemical industries, for pharma industries, because it prevents a kind of patent evergreening which is oftenly done by innovator companies. Now what innovator companies do is that they come up with a particular compound, then that compound gives them protection for 20 years, and again they come up with different appendages, like they will come up with its salt form, again they will get their patent for its novel salt form. Then again that will extend the product life, then again they will come up with different polymers of that patent, again they will come up different use of that particular compound, then again they will come up with different particle size of that particular compound, and they will keep on evergreening their protection for that particular molecule, and which is called as patent evergreening. So this particular section, section 3D, is such that it prevents, it blocks such patent evergreening. So for the explanation of this particular subsection, section 3D, the salts, esters, polymorphs, metabolites, pure form, particle size, isomers, mixtures of isomers, complexes, combinations, and other derivatives of known substance shall be considered to be the same unless they differ significantly in properties with regard to efficacy. There should be significant efficacy of the new form of that substance, then and then only the patent will be granted. So the Indian Patent Act prevents such patent evergreening by using section 3D. Now let us come to the next subsection. Substances obtained by mere admixture are not patentable unless the mixture shows that it shows some synergistic effect. The next one is mere arrangement or rearrangement of the different components is not patentable. Method of agriculture or horticulture is not patentable. Process for medical, medicinal, surgical, curative, prophylactic, or other treatment of human or animals. Then plants and animals as such is not patentable. Then mathematical or business method or computer per se, program per se is not patentable. Literary, dramatic, musical or artistic work is not patentable, but it can be protected under copyright law. Method of performing mental act or playing games. Presentation of information as such is not patentable. Topography of integrated circuits is not patentable, and the traditional knowledge being known is not patentable. So section 4 is specifically related to atomic energy. So inventions relating to atomic energy are not patentable. So after knowing what we can patent, what is the invention, what we can patent and what we can't patent, what is not patentable according to the Indian Patent Act, uh, we will come towards what is the structure of a patent. Now, while filing a patent application, we can file a patent application in the form of provisional specification, or we can file a patent application in the form of complete specification. Now, what happens is that many patentees or many innovators make a mistake that they wait till the till the complete work has been done on a particular invention, and then only they try to protect their invention by filing a patent application. Or many times what they do is they publish their invention in some seminars or in some publications, and then later on they come to know that, oh, I should have patented this earlier, or I should have filed a patent for this particular invention earlier, and then only I should have published this particular information. So if you have some idea which can be workable, but you don't have full details of working of the invention, then you can go for filing a provisional specification. And then within a period of 12 months, you can fully work on the invention and file a complete specification within a period of 12 months from the date of filing of the provisional specification. So that is a privilege given by the Patent Act to the inventors or to the patentees. Now the particular difference between the provisional specification and complete specification is that provisional specification describes the invention, but complete specification, along with the description of the invention, it describes the manner in which the invention should be carried out. So, looking at the structure of the patent, there are different fields in the patent, like title, technical field, background of subject matter, summary of subject matter, detailed description of subject matter, and drawings. Then separately, we need to file abstract. A complete specification contains one extra field, that is claims, which are very important part of a patent. Now, let us look at in detail in those particular parts, like a specification contains a title. So how should be the title? So remember, while drafting a patent, it is just like drafting a story. You have to give the title to the story, then you have to tell some background about what your invention is, and then you have to describe in detail what your invention is, and then at last at the climax you have to draft claims of your invention, and tell that, see, these are my claims, and nobody else should use those this invention, which is mine invention. So coming to the specification, the title should describe in general nature of the invention, and it should not contain anyone's name, fancy name, a trade name, a personal name, or any abbreviation. So then it comes about background of the invention. So in the background of the invention, you have to explain what is the prior art in that particular invention, means what is the person skilled in the art know about the particular field of the invention. So you can give the references about the patents, you can give references about different articles, that this is particular field and so many people have done this work. And at the last, you have to say your point, that all those prior art, all those patents which are there in this particular field are having this disadvantage. And because they are having this disadvantage, because they are having this problem, particular problem in this particular field, I have come up with a novel solution to that problems. So that is